Hey guys, what's up? I am hot and tired of my power being off because it is hot in here. The generator does not run the air conditioner, but it does run the internet, so I'm grateful for that. Can you hear me okay? We're supposed to go to a water park this weekend, but if we don't have electricity, we can't go because we can't leave the dogs in the hot house. Which means we have to stay in the hot house all weekend. I was so looking forward to the air conditioned drive to Orlando and the cool water at the water park. And we have another hurricane coming. Okay, enough about my bad news. Let's read some motions. Let's read the most ridiculous one first. So the hearing is in 2 hours, and I hope these are the motions that they're going to be talking about. I don't know which ones have been already decided because I don't know what they actually got to talk about, because I think they talked about some things on the phone when the hearing last time. I don't know what all happened. I think that some people were talking on the Zoom call and there were technical difficulties with the defense attorney's Zoom or something. So I don't know what got done and what got decided. But this is the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. Civilian clothing and no restraints, I'm okay with. I'm actually okay with hair and makeup. But I think they want like professional hair and makeup, and I don't think she has a right to professional makeup artists come in and do her makeup. Comes now, I mean, like, I don't want my tax money going to pay for a makeup artist for her. That's all I'm saying. Comes now the defendant, by and through the undersigned counsel, moves this honorable court for an order permitting defendant to appear in all court proceedings pertaining to trial in civilian clothes without restraints instead of jail uniform. In addition, the defendant requests that she be permitted the right to having her hair styled and access to makeup. In support thereof, defendant states the following. 1. Statement of facts. 1. Defendant is presently incarcerated and is scheduled for trial on October 7, 2024. 2. Defendant has been incarcerated for over 4 years, and the defense would like access to professional hairstyling, cosmetics, and civilian clothing without restraints throughout defendant's trial appearance in respect for the court and prospective jurors. 3. Without the court entering an order permitting her access to such, the right to receive a fair trial will be impermissibly infringed upon. 2. Legal argument. A. Right to appear in civilian clothing. The presumption of innocence is a basic component of the fundamental right to a fair trial. Since the defendant, pending and during his trial, is still presumed innocent, he is entitled to be brought before the court with the appearance, dignity, and self-respect of a free and innocent man, except as the necessary safety and decorum of the court may otherwise require. He is therefore entitled to wear civilian clothes rather than prison clothing at his trial. See Atkins v. State, Kennedy v. Cardwell. 5. Here, defendant is scheduled for trial on October 7, 2024. The defendant will be transported from the Orange County Jail daily for her trial proceedings. Defense counsel will be providing the defendant with professional attire for the court appearance. In addition, the defense will need to obtain defendant's measurements. Well, are they going to tailor her clothes? What the heck? Therefore, defendant requests this court to enter an order placing the Orange County Jail on notice that 1. The defense is permitted to take defendant's measurements, and 2. Defendant is permitted to dress out in her civilian clothes for her trial proceedings from October 7, 2024 to October 25, 2024. B. Right to appear without physical restraints. 6. Allowing a defendant to appear before the jury in restraint devices is an inherently prejudicial practice that undermines the presumption of innocence and the right to a fair trial. Generally, a defendant in a criminal trial has the right to appear before the jury free from physical restraints such as shackles or handcuffs. See Miller v. State. 7. On September 19, 2024, defendant appeared in court bearing handcuffs and shackles. Defendant's hand restraints made it difficult for her to communicate with counsel in written note-taking form. In addition, it is reasonable to assume that the next court hearings will be covered by local and national media, and if defendant is put on display to prospective jurors in jail garb, they will naturally be led to doubt her presumption of innocence. Therefore, defendant is requesting that the hand restraints be removed at all court proceedings from here on out, and that both shackles and handcuffs be removed during trial proceedings. C. Right to control appearance in the courtroom and before the jury. 8. The courts have recognized that a defendant's appearance can significantly impact the jury's perception and consequently the fairness of the trial. In Estelle v. Williams, the U.S. Supreme Court noted that compelling a defendant to stand trial in prison or jail clothing could impair the presumption of innocence, which is fundamental to the adversary system. See Estelle v. Williams. D. Allowing the defendant to present herself in a manner that does not unduly prejudice the jury is essential to ensuring her right to a fair trial and upholding the presumption of innocence. And while the court in Estelle specifically addressed prison attire, the underlying principle applies broadly to any aspect of a defendant's appearance that could influence a jury's perception. Defendant has a right to appear before this court and prospective jurors in the same manner as she would outside of confinement. Cosmetics and hairstyling is standard practice in presenting a professional appearance if the individual so chooses. By extension, incarcerated males are permitted a fresh shave and haircut. Accordingly, the defendant requests that she be permitted access to cosmetics and hairstyling throughout her trial proceedings, including voir dire. Aw, thank you, Flash. I don't know what to think about that. Like, they've already said she can wear civilian clothes, which that's ordinary. They've already said she doesn't have to be shackled. And I know that was when she was pro se, but does that just go away now because she has a lawyer? I would think that would still be. I don't know. I don't know enough about the law to know if. So, orders that he's already granted, do those just go away because now she has a new lawyer? How does that work? I don't know. And she's obviously getting her hair cut. Don't they have people in the jail that does that stuff already? So why do we need a professional makeup artist? Can someone just give her some makeup and let her do her own makeup? I mean, does my taxes go to pay for a professional makeup artist and a beautician for her? Like, what? Sorry. Just don't get it. This is not your Broadway debut, woman. This is a trial. I know. That part I did get from the last hearing. The of all the things that got taken care of in the last hearing that we heard, that one I heard. But I didn't hear anything else get settled that day. He's going to stay on as a consultant, but not going to testify, which I don't really know what that means. I don't know why he's not testifying. They didn't say why he wasn't testifying. I don't know if he's worried about skeletons in his closet or what. That's the guy that got arrested for storing body parts. I mean, he's a medical examiner. I don't know if they were like, if he was supposed to dispose of them correctly and just kept them, or I don't know. I need to do a deep dive on that guy because that's kind of creepy if you ask me. Oh. Oh, did they? See, I missed the phone call part. I'll have to look at that. I do have the app. I didn't even think to look at the app. I just downloaded the app the other day and I haven't even looked at it since I downloaded it. I don't know why. I'll have to look at that. And I have good news. I'm not having back surgery. Not yet, anyway. I am going to try the steroid shots first. The pain doctor talked me into it. Actually, he scared me about the surgery. So we're going to try the shots first and maybe a nerve block. And my first shot is on the 23rd. So it might, I don't know if the trial is still going to be going on then or not. According to Owens, it will still be going on, but it's going to be early in the morning when I go to have it done. So it shouldn't, I should be back. Well, I don't know if I'll be back before the trial starts that day, but I'll just start it when I get back home and we'll just be a little bit behind. So it won't be a big deal. It won't be full-blown surgery. So I should be able to just come in and we'll just start late that day. So that's good. I'm putting like everything on hold for the 3 weeks in October. So I even told, like, I rescheduled a doctor's appointment and I'm like, I'm busy in October. Let's make it for November. Because like I'm halfway to monetization now. I freaked out last night. I was like, honey, come here, look at this. I'm like, maybe after this trial I can get monetized, which means I'm gonna have to keep doing trials. So I gotta figure out, what do I do next to keep it up? Okay, let's read some more. Okay, so we read Right to Hair and Makeup. What is this one? This is okay, let me go back and share. This one is crazy. Oh, no, that's the wrong one. This one. State's request for protective order. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. The defendant in her third amended witness list. I tried to find the witness list and there's another one that I could find the state's objection to, but I couldn't find the list. It was an evidence list. I couldn't find the list. I could find where I can't remember what it's called. Provision of the evidence list, where they sent the list to the state, but I couldn't find the actual evidence list. So I can't find the witness list either. But this is interesting. This is going to be a spicy trial, y'all. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as followed. The defendant in her third amended witness list has listed the following people as witnesses, and I do not know why people is in quotation marks. Y'all see that? Why is people in quotation marks? A. Custodian of Records, Orange County Office of the State Attorney. B. Domestic Violence Supervisor for the Office of the State Attorney, 9th Judicial Circuit, Orange County. C. Victim Advocate Supervisor for the Office of the State Attorney, 9th Judicial Circuit, Orange County. D. Misdemeanor Supervisor for the Office of the State Attorney, 9th Judicial Circuit, Orange County. 2. The state requests a protective order under Florida Rule of Criminal Procedure 3.2201 because anything these witnesses could say about the defendant and the decedent would be protected by the work product privilege. Florida Rule of Criminal Procedure 3.220G1. 3. If the defendant wants public records from the state's attorney's office, she should do what everyone else has to do, file a public records request. 4. Subjecting prosecutors and their staff to this type of discovery of their investigations would require disclosure of work product and seriously impede criminal prosecutions. Egan v. DeManio. 5. We believe the trial court was right the first time in denying the pre-trial defense efforts to subpoena the two state attorneys and inquire into oral communications, sworn or otherwise, between them and a state witness. The oral and unrecorded statements of witnesses to a state attorney are privileged as work product and not subject to discovery. Olson v. State, C. State v. Rabin. All ones should know that. That's why this one is bizarre to me. 6. Opinion work product involves a lawyer's impressions, conclusions, opinion, and theories on her client's case. Opinion work product is an absolute or nearly absolute privilege. Horning-Keaton v. State. 7. Fact work product concerns what the attorney did and what she learned in her role as attorney. As the name suggests, fact work product is factual information which pertains to this client's case prepared or gathered in connection therewith. 8. The fact work product is discoverable only if the parties seeking this work product show the court 1. The need for this fact work product to prepare a party's case, and 2. That without undue hardship, the party is unable to obtain the substantial equivalent of this fact work product by other means. Thus, need and hardship elements must be alleged in the motion to compel and establish to the court's satisfaction at an adversarial hearing. The state is at a loss for what non-privileged testimony any of the people, again, people is in quotation marks, any of the people listed above could provide in this case. 10. Therefore, the state is requesting the court to enter a protective order to prevent any employee of the state attorney's office from being a witness in the case. That is crazy. That is crazy. That is just absolutely insane. I know what he's trying to do. He's trying somehow to show that George has multiple DV charges against him. Okay, well, that explains why I couldn't find it. Yet, well, he didn't say their names. He just said their positions in the state's attorney's office. Canone? That's the only Massachusetts judge that I know. Shanna Gardner. That sounds familiar. Why does that sound familiar? You know, I'm only covering 2 cases right now and I can't keep them straight. I told Recovery Addict that, because he was like, oh, Sarah Boone has a new lawyer. Now she has 2. I was like, no. She has 3. And I told him, oh, well, then I don't know why she sounds familiar. I don't know. And I told him the name of Ashley Benefield's appellate attorney instead of the right name for Sarah Boone's 3rd lawyer. So then the next day I had to tell him, oh no, I got them mixed up. I was like, I only have 2 cases and I keep getting mixed up. How do lawyers do it when they have a whole bunch of cases? I guess I'm going to have to learn how to juggle all this stuff. And I still have to do my video on the Devil Made Me Do It case. Man, I rewatched that movie, and the real case is nothing like that movie. Okay, let me see. What do I have left? The one I have left is... Oh, wait a minute. Oh, don't do this to me. Where'd it go? I lost it. Where did the motion to... I had it and it disappeared. And now I can't find it again. I think I already read it in one of my other videos. I thought he was going to be a prosecution witness. He can get up there and say, I mean, because he did say at the time to the officer that he's always beaten on her. I'm going to do the Kentucky case. I'm doing that one. I watched the hearing yesterday on Recovery Addicts channel. He's doing it. He's actually probably going to go... He's going to go to Kentucky when they have the actual trial. And I watched that hearing yesterday with him and I was like... And then last night I saw all of my numbers go through the roof for me through the roof. And I was like, I need to do that hearing on my channel and start covering, like doing it from day one, covering it, so that I can be ready when it does finally go to trial. Um, and get on the bandwagon with that one. I think that Brian can testify to the fact that he was always hitting on her. But excuse me. Have you guys seen the video of when the police were called to their house one time and the cop is trying to get Sarah to tell him what did he do, and she's like dancing around about being hit. Like she's like, "Oh, well, he came in there and woke me up." And I'm like, "Well, I can't let this happen. I can't let it escalate. So I go downstairs and I smoke a cigarette." And the cop's like, "But you said he hit you. Did he hit you? Where did he hit you?" And she's like, "Well, yeah, when he woke me up, he hit me in the ear." It's like she didn't even want to say anything. But like, you called me. Why did you call me? It's like she almost didn't even want to say it. And the cop, I mean, you can tell that the cop doesn't believe her. And it's the way she presents the story. And it's also the way she presented it that day when she called the cops. It's like she can't. The way, and I think I mentioned this in one of the other videos I made about her. She started off with, we were on the back porch listening to music and we were drinking wine. No, that's not why you called the cops. You called them because you woke up and found your boyfriend dead in a suitcase. It's like she doesn't know how to tell the cops why they were called. You start with why you call the cops. You don't start with the whole backstory of the incident. That they don't care. They're out here because you called them for a reason, and that's what you start with. It's like she doesn't, and I'm not saying that she's lying. I'm just saying, like, she doesn't know. I don't know if it's subconscious, like she doesn't want to tell them what is going on with them, or she doesn't know how, or like I don't understand. I guess I was in a abusive relationship once, but it wasn't physical. It was emotional and SA, and I don't I don't he didn't hit me. Like he never hurt me. It was like emotional SA. I don't know how to explain it, but it was like just making me do stuff I didn't want to do and stuff like that. But um he didn't hurt me. So I don't know the mindset of somebody that gets hurt and stays, but like calls for help, but then turns around and bails them out the next day. Like I don't know. I don't get that mindset. Like I don't. So I can't understand where she's coming from. But like she keeps telling people, right, right, manipulate, exactly. Yeah. And then like I'd go to leave, and if you go out that door, you're never coming back. Yeah. It wasn't. It wasn't painful. It wasn't hurtful. It was manipulation. Yeah. Um. So, um, like I don't get like women that like, oh, he beat the crap out of me. come get him and then go bail him out the next. That I don't understand. That I don't get, because it's never happened to me. And like, if someone hurts you, why are you gonna go be with them again? I don't. But calling the cops and then not wanting to tell the cops exactly what happened. But that seems what she was doing in that one video. She's a strange woman. Like, I can't figure her out. I'm so ready for this trial. And Owens keeps trying to delay it. And I think a lot of these objections from the state, like the protective order thing I just read, he doesn't have time to go through the regular channels of asking, you know, filing whatever he needs to get FOIA requests or whatever that he needs to get this information. He doesn't have time to go through regular channels because we're less than a week away from the start of the trial, and he doesn't have that kind of time. So he's just calling them as witnesses, which he can't do. And I'm sure he knows he can't. He's already throwing spaghetti at the wall to see if it'll stick, because he doesn't have time to do things the way he's supposed to do it. I'm sure he knows that. And that's why he's doing it this way. So, and he's going to try whatever he can, for his client. That was so much fun. Oh my gosh, that was so much fun. The only time that I lost my patience was the jokes about Buchanan's name. The only time, because it was like a week later and people were still doing it. And I lost it. I was just like, you guys are infants. The next time somebody does it, you're getting timed out. I'm just like, I was done. I was like, don't do it anymore. I was thinking a while ago, the only thing that like, I want my channel to grow. I want to make a little bit of money. I know it's not going to be a fortune. But we need a little bit more money than what my disability and his minimum wage job pays. Well, people that don't mind that kind of stuff, it's funny. It is funny. I'd never even heard that word before that. I had to Google it, and I was like, ew, that's nasty. Now I'm afraid to Google words when I hear them in chat, don't know what they mean. I'm afraid to Google. I was like, last time I Googled something. But I was just thinking about all of the, I'm going to miss out on stuff when I'm doing trials, the same trials that other people are doing. Like, I'm going to miss being in modding for Alita and being in other people's chats when they're covering trials and stuff. But so I have to think hard about it if I'm going to do trials. Oh well. We'll see what happens. If it's meant to be, it's meant to be. If it's not, it won't. And I'll still be on Alita's, being her mod. Okay, this is, like I said, I don't know what happened. I had the other one pulled up, and now I guess I accidentally did something to it. I don't know. So this is the state's motion to strike defendant's motion to suppress statements at OCSO and state's response to defendant's motion to suppress statements at OCSO. So it's to strike and their response. And I think I already read the motion to suppress the statements already once. So this is the state's response. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. The defendant's motion is legally insufficient. The defendant recites allegations of facts, but not why any particular fact or facts is an issue. The reasons for suppression, as required by Florida Rule of Criminal Procedures 3.190H2, is a boilerplate assertion that it violated the United States Constitution and the Florida Constitution. There is no different than stating a search was performed illegally and improperly and unlawfully. State v. Christmas. Oh, that's a cool last name. Motion to suppress that cited 11 authoritative causes was legally sufficient. The defendant has not cited even a single case that authorizes the court to grant her the relief she is requesting. The state is left in the dark about what specific issue or issues the defendant is claiming and what legal authority there might be for the court to grant the relief she requests. State v. Butterfield. The court should strike the motion as legally insufficient. 2. The state objects to any additional claims being raised at the hearing that were not specifically pled in the defendant's motion. State v. Christmas. 3. In paragraphs 5 and 6 of her motion, she alleges that she was detained for 14 hours and during this time, she provided a statement to law enforcement. She does not challenge the admissibility of this statement. Chavez v. State. 54 hours of detention does not make a statement involuntary. When was she detained for 14 hours? 4. Paragraphs 7 and 8 of the defendant's motion allege that law enforcement asked for the defendant to turn over her phone and that she provided the means to unlock it to law enforcement. Bell v. State is informative on this issue if it is the defendant's position that this somehow rendered her statement the following day involuntary. 5. Bell makes it clear that the police, having seized evidence from a suspect, and the suspect knowing they have seized evidence from her, only goes toward the analysis as whether a future interrogation is custodial, not whether a future statement is involuntary. Because Miranda warnings were provided at the beginning of the interview the following day, this is not a relevant factor for the court to consider. Bell is also informative on the distinction between a Miranda violation and an involuntary statement, which will be discussed below. 7. Paragraphs 9 through 11 of the defendant's motion imply that law enforcement was being deceptive in their manner of summoning her for an interview she did not know was going to occur. Pursuant to Bell, this goes to one of the Ramirez factors in deciding whether Miranda warnings were required, not whether a statement is involuntary. 8. This is different from the deception that would lead to an involuntary statement. The defendant received no promises of hope, leniency, or misrepresentations about the law. Johnson v. State. Both the United States Supreme Court and the Florida Supreme Court have held that deception alone does not negate voluntariness. Wick v. State. This includes misrepresenting a co-defendant statement, false suggestions that law enforcement could arrange a satellite system to put a defendant at the scene, exaggerating the amount of DNA evidence against the subject, informing a suspect that law enforcement was investigating a missing person case rather than a homicide, Writing DNA evidence on a whiteboard in an interview room prior to any DNA analysis being performed, and false representations of physical evidence that did not exist. 9. Luring the defendant to the sheriff's office under the guise of returning her phone to her, if that is in fact what happened, does not make this statement involuntary. It only goes toward whether Miranda should have been read, and it was. 10. Paragraphs 12 and 13 also only go toward the first Ramirez factor as to whether Miranda should have been read to the defendant. She was led upstairs to one of the interview rooms in the sheriff's office by Detective Lowen, where an interrogation ensued after Miranda was read to the defendant. 11. Nor is there coercion, although the defendant has not specifically made that claim or cited authority. Martin v. State. Allegations that law enforcement, 1, threatened the subject with the death penalty, 2, deluded the subject as to what he could expect for himself and from a jury if he confessed, 3, deceived the suspect as to the amount of time he had to cooperate with law enforcement, 4, promised their favorable testimony and use of their influence during his trial if he cooperated, 5, promised to arrange a visit for him with his girlfriend if he cooperated, and 6, exploited his religious beliefs by relying on a version of the Christian burial interrogation technique. Did not render his statement involuntary, though it presented the very outer limit as to what tactics law enforcement may employ when performing a custodial interrogation. 12. They didn't do any of that stuff. They did not promise her anything. 12. Although the defendant never states that part of the reason she believes her statement should be suppressed was the minimization of her Miranda warnings, nor cites any case law on the subject, the state infers that she believes this is an issue due to what she has underlined in paragraph 15 of her motion. There are several cases addressing the issue of minimizing the importance of Miranda warnings. Ross v. State, Thomas v. State, Wright v. State, Chaffin v. State. 14, saying this is something I have to do is not minimizing according to Wright, which is analogous to Detective Kepsel saying, so I'm going to read you your rights again because we have to talk about that. We just have to do it. They were read in a normal cadence like in Chaffin. There was no delay in reading them. The defendant is not a juvenile, and there is no claim that she is of below average intelligence. Oh, no, because she's an excellent student. She got straight A's in school. She was an excellent student. She had been read her Miranda warnings just the day before and acknowledged this. It is the defendant who says it is normal protocol. 15. These statements by law enforcement did not render her waiver of Miranda rights involuntary or her statement involuntary under a totality of circumstances analysis. 16. In the balance of paragraph 15 of her motion, the defendant outlines the Miranda warnings as they were given to her by Detective Kupsel. 17. Paragraph 17 through 21 outline what she believes the sheriff's office Miranda card says and how it differs from what she was told by Detective Kupsel. 18. Interestingly, the defendants believe that this creates some sort of legal impediment to the admissibility of her 2-hour statement that day is not backed up by a single citation to any legal authority within or without the state of Florida's court system. 19. Instead, she makes a boilerplate assertion in paragraph 22 that her statement was involuntary and her waiver of her Miranda rights was involuntary. Fortunately for the state of Florida, there is case law on this issue. 21. There is no specific way that Miranda warnings must be given, and with all due respect to the Orange County Sheriff's Office, they certainly do not have the authority to tell this court what sufficient Miranda warnings are. Rygertink v. State, Kramer v. State, Morris v. State, State v. Owens. 22. While the 4 required warnings have become embedded in police practice, the specific words used vary, and the Supreme Court has not dictated the words in which the essential information must be conveyed. Morris v. State. There is no talismanic incantation required. I love it. You're not doing a spell. There is no talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed. Riger Tink at 890, citations omitted. Rather, the inquiry is simply whether the warnings reasonably convey to a suspect his rights as required by Miranda. The crucial test for determining whether police gave a proper warning is whether the words in the context used, considering the age, background, and intelligence of the individual being interrogated, impart a clear, understandable warning of all his rights. 23. Detective Copsall specifically instructed the defendant on each of her four Miranda rights. 1. Right to remain silent. 2. That anything said can be used against her. 3. She had a right to an attorney before and during questioning. And 4. A lawyer could be appointed if she could not afford one. The detective then asked the defendant if she understood these rights, and the defendant said she did. 24. State v. Owens is directly on point. There, the defendant was read the four Miranda rights, asked if he understood them, and asked if anyone had threatened him or promised him anything. There is no mention of any question about whether the defendant wanted to talk to law enforcement after he was given Miranda warnings. This is apparently the Federal Bureau of Investigation's Miranda warnings, which were described as exemplary. 25. The Miranda decision never contemplated that waiver of counsel could be accomplished only by the use of the words, I am willing to answer questions without the services of a lawyer. There is no magic in these words. Any clear and unambiguous conduct by a person who has been advised on his rights, which indicates his willingness to answer questions without a lawyer, is surely sufficient. State v. Craig. Therefore, if the court does not strike the defendant's motion to suppress for being legally insufficient, it should deny it on its merits. If the court believes there was a Miranda violation, then the defendant's statements are still available for use during cross examination. Only if the court finds the statements to be involuntary will the state be prohibited from using them in cross examination. I'm reading all the chat that I missed while I was reading. So I do remember that I did do I did read the other one because I remember saying about implied consent, like as a nurse, if you go in and you say, I need to take some blood, um, and they hold out their arm, that's implied consent. Like you don't need them to sign anything saying yes, you can take my blood. So I do remember. But now there's a amended one where he goes back to the day before when she was talking to Officer Rodriguez. However, she wasn't in custody. So Officer Rodriguez didn't need to read her the Miranda rights. But then when Capsule and Scott, forgot his last name, Chelsea and Scott, when they got there, they didn't Mirandize her right away, but then the part, and I don't think there's a video of this. I think there might be an audio of it somewhere. I couldn't find it. Where they've got her in a police car talking to her, and they did Mirandize her then. So, she was Mirandized both days. And I do remember when she was arrested, she said, "So this was just a trick." And no, it wasn't a trick. They needed to talk to her at the sheriff's office. So it wasn't a trick. She just, I mean, maybe they should have said, instead of saying, "Oh, I'm pregnant and I don't feel like going all the way over there to give you your phone," maybe she should have just said, "Well, can you come get your phone? Because we need to talk to you about something too." But still, just because she didn't say, "Knowing these rights, are you willing to talk to us?" She was absolutely willing to talk to them. She wouldn't shut up. It was 2 hours. She wouldn't shut up. So those are the things I think is going to be covered in the hearing today. And I guess I'm going to go listen to the rest of that hearing that was on the phone call. I'm going to check out the Court TV app and see if I can hear the rest of that. And the hearing's going to be at 3. So I'm going to go take a little break and get something to eat. And I will see you guys back in about an hour. So thanks for coming to listen. I just felt like I needed to read those because I'd read all the others and I knew that there were a couple that I hadn't hit yet, especially the protective order one, because I thought that one was extremely interesting. Because I was like, man, if they're gonna keep fighting over stuff that's like obviously, I mean, stuff that they should know that they can't do, like, is he gonna keep like trying to do stuff, trying to get away with stuff like that? This is gonna be a spicy trial. This is gonna be good. So, okay, I will see you guys in a little bit. Talk to you later. Bye.